Hi guys, and welcome back to Contract B, and this is the third video in our series on discharge by performance and agreement, and now we're up to discharge by agreement. And first thing we need to note about this particular part of contract law is that once you've got a contract on foot and then you don't actually want it done that way, or you don't want it at all, there are some options you have open to you. First up, you can vary the agreement. And in this scenario, the original agreement will stay on foot and you just change some of the terms. Usually that will be the case where you're just tinkering around the edges with some of the terms of the contract. However, if you do something fairly serious, like try and substitute a whole new party for one of the parties, then you're probably going to be actually cancelling the original agreement and getting a whole new one on foot between new parties. Now that is called novation, and we'll look at that in just a moment. The other main option that you have to you is discharging the agreement entirely. And how do you do that? Well, you discharge an agreement by fresh agreement. And what you have to do is you have to engage in all the normal requirements that you would otherwise have for forming a new agreement. And the substance of that agreement is simply to cancel the old one. Very importantly, you need to have consideration in that agreement. If you don't, or if you're not contemplating having any consideration between the parties to discharge the agreement, then you need to do it in the form of a deed, because obviously if you remember back to your studies on consideration, you can get around that whole requirement simply by doing whatever it is that you need to do in the form of a deed, and that solemnness of the deed replaces the requirement for consideration. Now, in terms of consideration, what consideration has to move and by whom to whom? Well, if it's an executory contract, that is one where both parties have yet to perform, then the promise by one party to the other party and vice versa to release the obligation will be sufficient consideration. So it's pretty easy peasy. One party just says, hey, let's call it quits, and the other party says, yep, that's fine. Problem solved. You've got your fresh contract to discharge the old contract, and you've got your consideration moving from one party to the other and vice versa. So it's all good. The situation becomes a little bit more murky where the contract is not executory and one party has done the performing. In that case, the party that has done their performing has a contractual right of action against the party that has yet to perform. They could actually go ahead and sue them and, ask for an order for specific performance. So what the party that wants to be released from this cause of action has to do is to pay fresh consideration to the party that is releasing them from that cause of action. And this process is called accord and satisfaction. The accord is the agreement to release that non-performing party from the contractual right of action that the other party would otherwise have. And the consideration that the non-performing party pays over to be released from that cause of action is called the satisfaction. The text goes into a bit of a long-winded discussion about accord and satisfaction. Really, it's not that hard. It's just where one party gets released from a cause of action that the other one has against them. The other option, as I said, simple, just do it all as a deed and you get around any consideration problems there. Now, in relation to variation, usually an agreement to vary a contractual term will be a whole fresh new contract. So again, you've got to have all of the elements of formation there for it to become legally binding, including consideration, as you can see there. The text does go into some discussion about what happens when a contract is required by statute to be in writing. So, for example, contracts to dispose of an interest in land. Those contracts all have to be in writing. And the question there is, well, what happens when you want to vary one of those contracts? Does that variation have to be in writing? Then yes, it certainly does. If the original agreement has to be in writing according to something like the statute of frauds, then a variation to that contract will also need to be in writing. One thing you do need to know though, an agreement to discharge a contract that must be in writing does not itself need to be in writing, because there you are not actually tinkering around with disposal of, for example, an interest in land. You are simply making a fresh contract to discharge an original contract. So that's variation. The other interesting point about variations is novation. And novation is where most novations are in relation to substitution of a party. And as I said there, you often see this kind of thing happening orally or happening by virtue of a contract that's just not clear. And, a lot of the case law is about courts just trying to disentangle exactly what the parties have tried to do and work out what's happened to the original contract. What happens with a true novation is that one party entirely steps out. So you have a fresh agreement between the first party and this new third party that steps into the contractual arrangement. Now, whilst the actual practical effect of it will be that that third party just steps into the shoes of the second party and keeps performing all their contractual obligations, what actually happens, so far as we're concerned with, is that there is a whole new contract, and that whole new contract is between the first party and the third party that has stepped in. Okay, even though it might seem, for all intents, that it's just the same old contract continuing on, usually that will be the effect. So after the second party exits, obviously that old contract drops to the wayside, and you have that new agreement between the third and first party just continuing on. Now, in terms of consideration, obviously you've got A giving up their rights to make B perform, so that's a form of consideration moving from A. What does B do? B will either pay some money to A, or they will procure C to perform their obligations instead of the party B themselves. All of the parties have to consent to the arrangement, and if everything goes to form, then you will have the ending of the original agreement between A and B and the beginning of a beautiful new relationship between A and C. Now, often, as I said, the court has to disentangle what happened between the parties, and for better or worse, the text refers to the case of ALH Property Holdings and the Commissioner of State Revenue. Can I just say, you won't hear this very often, do not worry about reading this case in the case book. You will go insane. What you need to do is just have a listen to my description of the case and all your problems will be solved. You really can't make head nor tail of what is said in the case book, and I've had to kind of piece everything together by reading the decision itself, reading some other secondary sources, and coming up with my potted version for you guys. So here it goes. Here is ALH and the Commissioner of State Revenue. What you had in that particular circumstance was a sale of a hotel and some land that it stood upon from Oakland, a company called Oakland, to Permanent Trustee. And Permanent Trustee changed name, a few other things happened. In any event, there was this transfer that happened in November 2003. There was a side arrangement between Oakland and another developer that related to a different portion of the land, not the land that the hotel stood on. And that was all well and good, but then Permanent Trustee wanted to exit the arrangement and they wanted to bring in ALH to perform their duties for them in June 2008. And here is just the classic case of bumbled drafting, causing a whole lot of pain and a lot of money in terms of lawyers' fees. Woohoo. June 2008, we have what is called a deed of consent and assignment. Yeah, assignment. That was the word that kind of mucked everything up. What you actually had was the typical kind of novation arrangement happening here. So with the usual novation, you will have a deed between three parties. Party A, the original party to the contract. Party B, the original party to the contract. And Party C, the new guy on the block. Okay, this deed normally will say all the things that this June 2008 deed did actually go ahead to say. So there it said, PTC, the original purchaser, agreed to assign its rights to ALH, and Oakland, the original vendor, agreed to this assignment between PTC and ALH. So it's all set up as an assignment, really. ALH promises to PTC that it's going to duly perform all of PTC's obligations as purchaser under the original 2003 contract. And critically, Oakland agreed to release and discharge PTC from all of its liabilities under that original 2003 contract. So there you have the contentious arrangement there, the deed. In October 2008, what you had was a further complication. You had a deed of termination. And what the deed of termination did was it purported to rescind the 2003 original contract between Oakland and PTC. Instead of, as it should have done, purported to rescind the 2008 deed of consent and assignment. Okay. In the lower court, it was held that the effect of that deed of termination, even though it said what it was purporting to do, was discharge the original 2003 agreement. In fact, the lower court found, that what the deed of termination did was that it terminated the 2008 arrangement between the parties. It discharged the deed of consent and assignment. Okay, then we have in October 2008, at the same time, a fresh contract of sale was entered into between Oakland as the vendor and ALH as the purchaser. And this time, the contract of sale related to all of the land originally purported to be transferred over to ALH, as well as that extra parcel of land that was previously going to be sold to a developer. Now ALH was going to take the whole lot from Oakland. Now, there was no real problem with that particular contract of sale. It went through and stamp duty was paid. About $300,000 of stamp duty was paid on that contract of sale. So there we have the parties' positions up to October 2008. And then in November 2008, the Commissioner for Stamp Duty has a little look back through this whole history of dealings between the parties and says, "Ooh, hang on a minute. We actually think that the 2008 deed of consent and assignment was just an assignment from a permanent trustee as purchaser to ALH as new purchaser. And the beauty of doing that would be that the deed of termination then, that purported to cancel the original contract, it really only terminated an assignment, and therefore it didn't actually bring that arrangement under Section 50 of the Stamp Duties Act. Now, Section 50 of the Stamp Duties Act basically runs like this. If you have entered into a contract of sale for the disposal of dutiable property, so property upon which stamp duty must be paid, and then you later go ahead and cancel that contract, then the Commissioner, subject to a few other things, had to refund any stamp duty that was paid on the original and now cancelled contract of sale. The Commissioner was trying to get around this, doing a bit of a fancy two-step, and said, well, you know what, we're going to assess duty on that 2008 deed of consent and assignment because we don't think that that termination brought it under Section 50. We think that this has got nothing to do with Section 50, and in fact you should be paying stamp duty on the deed of consent and assignment. And then there's this whole fresh transaction later on in October 2008 which you've already paid duty on. Not surprisingly, ALH objected. They did very wisely pay that stamp duty, so the fight really was about getting a refund of the duty that had been assessed on this deed of consent and assignment. And so the court had to disentangle exactly what that deed of consent and assignment did. If it operated basically as a contract of sale from Oakland to ALH with the exit of permanent trustee, if that's what it did, then it was a contract for the sale of dutiable property, and that sale was then terminated by the deed of termination, and therefore no duty would be payable on that deed of consent. Yes? But if it was just an assignment, the Commissioner could go ahead, assess duty on that transaction. The termination really had nothing to do with it because it wouldn't bring about a cancellation of a contract for sale of dutiable property. Yes? And so what the court did was it looked at the major facets of what had happened in that 2008 deed of consent and assignment. And really, it was not just an assignment that had been consented to at all. It operated as a complete release and discharge of permanent trustee. They exited the scene completely, and it was a fresh, novated contract between Oakland and ALH. And it just so happened that all of the terms and conditions of that new 2008 agreement between Oakland and ALH were the same as the original terms and conditions that were in the 2003 contract between Oakland and PTC. Okay, so don't have a look at this case. What you can do is take my word for it. The court just teased apart what exactly has to happen for a novation. They said this wasn't just an assignment at all. This in fact was the complete cancellation of the original contract and the beginnings of a beautiful new relationship between Oakland and ALH. So ALH had done the right thing. It paid its stamp duty twice. In the end, the High Court said, no stamp duty payable on that deed of consent, so you should be refunded that money. So that is the rather confusing case of ALH and Commissioner of State Revenue. Really, all you can get out of it is just, teasing apart the principles behind a novation. If you're going to read anything, I would just simply read the little potted version in the textbook rather than looking at the convoluted discussion in the casebook, and just noting that the main thing that the court was worried about was the main four things that happened in that deed. So Oakland had to agree to the assignment. ALH promised permanent trustee it was going to perform permanent trustee's old obligations, so it stepped in there, and Oakland released and discharged PTC from its original obligations, and therefore you ended up with this fresh new contract. And that is the issue of novation. Oh, I hope your heads are not spinning right now. The last thing we need to talk about is abandonment, and this is the main type of non-contractual discharge, and this is basically where the parties just walk away. And you see objectively from the behaviour of the parties that they just don't intend to enforce this contract any further. And here we have the case of Fitzgerald and Masters, and it kind of shows you the outer edges of the notion of abandonment. Probably I can't see a period of time going on much longer than this without a contract being classed as abandoned, but we had a sale by Mr. Fitzgerald of a half interest in his property to Masters. Now, this half interest was to be purchased by a purchase price that was payable over a number of years. Mr. Masters commenced payment of his instalments of the half interest of the land. He paid over half of the amount that he had to pay. The original contract was agreed in 1927. Then you have this difficult Depression era. 1932 was when over half the purchase price had been paid, but then Masters gives up and walks off the land. Now, before he did so, rather cannily, Mr. Masters had the contract stamped and registered. Okay, so this is a good way to preserve your equitable interest in a property, and I'm sure that you'll go and discuss the whole notion of equitable interests in property as opposed to legal interests in property. But he took the step of registering and stamping the contract, and that he walked off the land. No more was really said or done about this contract. Dear old Mr. Fitzgerald passes away then 2 years after that, so we're at 1953 now. Mr. Masters commences an action here, and the question was, well, had the inordinate delay of whatever it was, 21 odd years, had that indicated abandonment of the contract by the parties? And the court said, rather incredibly, no, it hadn't been abandoned. Now, very crucially here, we have the three things that the court has had on. The plaintiff obviously had an equitable interest in the property, okay? And this is where you have obtained an interest. You haven't got a legal interest because you haven't been registered on the title to the land, but nevertheless, equity recognises that you actually do have a say in the land. You have an interest in the land. More than half the price had been paid, and the contract had been registered. Okay, this is a fairly important step because it's kind of like a place marker. Okay, you haven't been registered on the title, you haven't been recognised as a part owner of that property, but nevertheless the contract itself had been stamped and registered, so you knew that there was some kind of equitable interest there underneath the legal title. And so despite the 21 years that had elapsed and Mr. Fitzgerald's passing, nevertheless Masters was successful in his action there. So the courts can let quite a significant period of time elapse before they will consider a contract to be abandoned. At the end of the day, really, like I said, it's going to be down to what the court construes as the objective intent of the parties, what their conduct showed to the reasonable person. So that's abandonment. And with that, we wrap up our discussion of death of a contract by discharge, either by performance or by agreement. Like I always say, if you have any queries or questions, just shoot me an email, send me a message, send me a text, shoot something on Facebook, but either way, clear up your difficulties with me. I'll be only too pleased to help. Other than that, I look forward to talking with you about the tutorial problem for this topic, and I hope to see you in the Zoom. Thanks guys, bye.